So, yeah, this was very common. So what Congress is saying in 1968 is that's not going to be tolerated. Okay? So that was the other major area that was sort of overlooked or omitted in the 1964 Civil Rights Act. Congress fixes that in 1968. Okay? There are several other things that end this discussion of the civil rights agenda at this point, but there are several other civil rights acts that we can talk about that have been, in fact, passed since then up to the current period. But a lot of that has less to do with race. Remember when we started this topic on civil rights, I said that we were going to focus on the issue of racial equality. For example, the 1972 Civil Rights Act had more to do with gender equality issues. Okay, so there have been several other very important civil rights acts that have been passed since 1968, but this is where my list ends. Now, you'll have to rely on the authors of the textbook for the other areas, gender equality most notably. Okay? Now, I want to turn our attention to another issue here for the next 8 or 9 minutes, just to wrap up this topic on civil rights. If we have a law or a policy that discriminates, and there is a challenge, there is a question about whether that discrimination can be tolerated by the 14th Amendment, the Equal Protection Clause, whether it violates the Equality, Equal Protection of the Laws Clause of the 14th Amendment. Here's how the courts, particularly the United States Supreme Court, approaches these questions. And that's a very awkward way of saying that. Let me back up and try that again. Okay? If you have a law or a policy that discriminates, how does the court, and there's some argument that it violates the equal protection of the laws guaranteed by the 14th Amendment, how do the courts look at that question? How do they address that question? And the easiest way to get at that is to identify what is the basis of the discrimination that's being argued. Okay? So if it's a law or if it is a policy that discriminates on the basis of race or ethnicity, the courts apply what is called the strict scrutiny test. Okay? They view race and ethnicity as suspect categories. And the assumption is that the law or the policy is unconstitutional unless an overwhelming justification can be provided for that discrimination. Courts view race and ethnicity as a suspect category. So any law or any policy that discriminates on the basis of race or ethnicity is almost certainly going to be struck down by the court as unconstitutional unless some overwhelming justification for that discrimination can be provided. And that, why does the court view race and ethnicity that way? I think it has to do with the history of the framing of the 14th Amendment. There's every bit of evidence for us to believe that what the framers of the 14th Amendment, back when was that amendment added to the Constitution? Anybody remember? 1868, just right after the Civil War, right? Every reason for us to believe that the framers of the 14th Amendment were mainly concerned about discrimination on the basis of race.